Hi everybody, and welcome to this month's Contract Administration Practice Group.
Well, thanks everyone for attending, and we will be talking today about a hodgepodge of situations. Our topic is what do I do now? So we'll be presenting a series of fact patterns, case studies, and be asking the question, given this set of circumstances, what do you do? What do you do now? And so we will be looking for quite a bit of audience participation today. Jim?
Absolutely, sure. What Matthew touched on is we'll sort of have, as Doug said too, a scenario, and we have some ideas, but we want to hear yours first. So please do raise your hand so Matthew can recognize that and get your comments flowing into this discussion, because that's really what brought us to this topic. What have been the responses to the queries of, what can we talk about next? And there are some of those scenarios here. And as we move into November and December, I just want to take a second and thank those of you who have replied to that question, what would you like for us to focus on next, and what would you like to talk about next as we establish those further future webinar topics. So it's really important that we try to get to the things that you are most interested in covering, and we appreciate your responses to that. So Matthew, let's go to that first slide, and we'll start with the first question. So you're out on a beautiful day on the job site, and as you're walking, you find that at the foundations, the contractor has already installed waterproofing, and you realize as you see it there that is one of the shop drawing submittals, the product data submittals, that you have not only have you not reviewed it, but you haven't even received it yet. So what do you do now? And I'd be interested in anybody's response to that issue.
We're taking a brief pause here, giving everyone a chance to raise their hand or type in the chat box. But again, this is the audience participation part, and we are looking for comments from the group as to what they would do in this situation. Do we have anything coming in yet, Matthew?
We do have one from Kevin O'Byrne, and a couple more popping in here. So Kevin just states that he would send a letter saying that the work is not eligible for payment. And then also Anthony Sanger says that he would issue an NCR and derive contractor response to the issue.
So the first response from Kevin was send a written notice to the contractor letting him know that that portion of the work is not eligible for payment. And the second comment was, can you repeat that, Matthew?
Sure. The second one came from Anthony Sanger. He indicated that he would issue an NCR and derive contractor response to the issue.
And I would assume, excuse me, that the NCR is a notice of correction of work, if I'm guessing what the NCR stands for. So if maybe we can get a follow-up on what the NCR, Jim, unless you know what the acronym might mean.
Anthony indicates that it's a non-compliance notice.
Non-compliance notice. Okay.
And then we also have a comment here from Abdul indicating that he would immediately call a meeting.
Well, let's take a look. Let's take a look at the next slide. As a series of possibilities. We throw these out for meat of discussion. So potentially, would you run back to your car, drive back to the office as fast as you could, hoping that when you actually receive this submittal, or if you had received this submittal, that you could review it and it may comply with your contract documents as originally issued. It is another option to issue a stop work order right there in the field. As the last response there, would it be appropriate to say to the contractor, perhaps you voluntarily stop working on this issue right now until proper review can be performed on the submittal, and have that meeting there at the site while you're there? Or perhaps you take no immediate action whatsoever because the general contractor is completely at risk and not you. I'd be interested in comments about these types of responses, and Doug, I'll hush and let you add to that.
Well, I think it's clear, and it comes through in some of the comments we got already, is that the contractor is performing work at a risk in that they are installing or have installed the waterproofing when it has not been approved through the submittal process. And the two comments we got, the first two comments we got back indicated that there's a recognition that the work is not in compliance with the contract requirements. Typically, general conditions, AIA language, and most other language says that the contractor is not to perform the work until the submittal has been reviewed and approved by the architect or the designer. So I think we can all agree that we've got a situation where the contractor has gotten ahead of himself and is performing work that is not in compliance with the documents. Trying to fill time to give people a chance to respond to these three, and as I do that, I'm going to go on and offer my 2 cents. I think the first thing I would do is I would go to the superintendent while I was out there on site and say, you've got an issue here. You're doing this stuff, we haven't approved it yet. I hope what you're doing, what you're installing, complies with the documents. If it doesn't, you may have to tear it out. I think the next thing I would do is I would go look to see exactly what it is that they're putting in. Take pictures, look at the labels so I could verify what it is they're installing. I would use that information not to go back and compare it with the documents right away, even though I probably would do that. But the emphasis would be, contractor, you need to get this submitted to me so that I can make sure that when they submit the documentation that they're submitting, that it actually matches what they've installed out there in the field. If I was right with the world, they will have installed exactly what we specified, and it'll be a non-issue, and it just resolves itself. I'm sorry, go ahead.
Oh, this is Matt. I was just going to say, I wasn't sure if you were done there. We do have a few comments and other points of the topic here, so I wasn't sure if you'd let me to...
So let me wrap up real quick. If it is not in compliance, if what they're installing is not what was specified, once I got that submittal, or once I got back to the office and saw that from looking at what they implied, what they had installed, and looking at our documents, if I saw that it did not comply with the documents, then I would follow the course of issuing a notice of non-compliance to the contractor, saying this doesn't comply with the documents. Tell me how you're going to correct it.
Matthew, go ahead.
All righty. Well, Kevin gave a comment here saying that at this point it's unclear if the work was indeed non-conforming, which I think you're kind of talking about there. It could end up being that the work ends up relating exactly to what ended up being done, but you don't know that at this point. But we have Brian Hergoat indicated here that he would rather gather information on the product installed on a site and if it is one of the approved products, issue a notice to the owner to have proceeding work stopped until this issue is resolved. We also have then from John Schlegeter, first determine if the submittal is for information or action. If for information, review and file. If for action, review for conformance and then proceed accordingly. And then we have here Anthony Sanger indicated the risk is with the contractor. Issuing a stop order may create liability for you. So that was something he indicated as maybe a warning. Chuck Coleman, on the other hand, put make note of observation and field report documenting submittal not received for review or approval, which is closer to response 4 in his opinion. And then lastly, we have info here from Justin Kerfoot indicating that he would notify the GC that he's installing at his own risk and that the submittal has not been reviewed as required.
And I think those ideas, as Doug has described, because the question was asked, we really don't know at this point if it is a compliant product or not. It's just simply that the sequence of what is described in the general conditions is supposed to happen is not happening. And so it is an opportunity to help the general contractor on this project to understand that this is not proper procedure, that this is not okay, and that there is a sequence to go through, and that's got to be followed. And perhaps there is no issue here, as Doug said, because it's a compliant product. But until you have that opportunity to review it and to look at what is in place, you just don't know. And there's so much of, a submittal that involves the application and installation. And I find in scenarios like this that the folks that are actually performing the work may not at all be aware of what the specific installation requirements are. And so it would be important to be sure that, as Doug said, when you're looking at what's there, not only the product that's in place, but how it was put there.
I think that's an excellent point. Even when you're talking, as this example is about the waterproofing, one manufacturer may recommend that it be installed vertically and joints be lapped 6 inches, and another manufacturer may say, no, my product needs to be installed horizontally in a shingled fashion and lap it that way. And as Jim said, the person that's out there actually installing it may have used a product on the last project and assume this was the same thing and put it in the same way, and it may need to go in differently.
Right.
I would not, and this was mentioned by a couple of people, I don't think I would at that point in time issue a stop work order. In fact, I would be very cautious in ever issuing a stop work order. As Jim commented before, at that point you don't really know whether or not the product being installed complies with the specs or not. So I would not say stop work. I would inform the contractor that he may have an issue that we need to get resolved.
Right. Absolutely. Yeah, you issuing a stop work order is puts things in a whole different game. Matthew, you want to go to the next question, or the next scenario, I should say?
Sure thing.
Okay, so you are again on the job site, and the project is about 75% complete. You have been there to review the application for payment and feel in agreement with that percentage, and so you have certified that application and have processed it away. And afterwards, you receive a call from a subcontractor whose work is complete and has been billed for and was included in this application for payment, and they are claiming that they have not been paid, and they are calling you to request the general contractor's bonding company's information. So what do you do now? Let's give you a minute to read that over.
As we present these issues and we get the responses back, I would be interested to hear as you respond also if you have ever run into a similar situation. So if you don't mind sharing that, I think that would be useful for the whole group.
While Matthew's collecting responses there, I'll give you a short story here. I have a good friend who's an architect who was on a project where an electrical contractor had 3 project sites within one county and had a tractor-trailer load of light fixtures that he moved from one site to the other until he had been paid for that trailer full of light fixtures 3 times. And then he left the country. And it fell upon, unfortunately, that architect in the end who had reviewed these applications for payment and had processed them to come to the table with his checkbook when the reckoning happened at the end, because he had confirmed that that material was on the site and should be paid for. It's a different scenario than we're talking about here, but...
Jim, was the architect responsible for all 3 of those projects?
He was. He was responsible for all 3. And they were county projects, but different projects. You know, they weren't all schools, but they were 3 different county functions. Just a exclamation point on how critical it is to be absolutely certain when you're certifying pay applications that work is there. And there are a lot of extenuating circumstances to that story, and we could probably do a webinar just on that.
Alrighty, we have a couple of responses popping in here.
Okay.
We have, as usual, Kevin. Thank you for always being tentative here. Kevin O'Byrne indicated that he'd alert the prime contractor to the sub's request and then provide the sub with the requested information. Additionally, we have Anthony Sanger here, who, Anthony, let me know if you have the ability to talk, if you have a microphone or a phone. We may want you to give some more info. Anthony indicates that he's actually had experience with this situation, and that he'd provide the bonding company information. But actually, Anthony says that he is on the phone. So Anthony, I'm just going to unmute you. If you want to share your information, we can go from there. So just 1 second here. Anthony, hopefully you can hear us now.
I can hear you fine.
All right, Anthony, I'm going to let you ask state your own statement here for us.
Actually, I have quite a bit of experience with this issue. Ran a very large program in Los Angeles building schools, and had this happen quite a bit. Basically, when you receive a call like this or a notification like this from a sub, provide the bonding company's information, then notify the GC and the owner both of the issue. If the sub does actually file a lien against the project, the general contractor has a few options. He can actually bond around the lien, or he could pay the sub directly and then withhold it from his sub. But effectively, the issue of payment of subs and sub-subs is an issue specifically for the general contractor. So from our point of view, we need to be aware of it because it can have an impact on the project. But it's through actions of the sub, it's through actions of the GC that the issue becomes resolved.
Thanks for sharing that. I would agree with that 100%. Notify the GC as well as the owner. A little twist in it is Jim threw in a little twist with the story he told. I think you may also need to be cognizant of the fact that if the sub's work was still ongoing, and say you're at 75% and he's billing 75% and he still had 25% to go, that might have an impact on your review of the next month's pay app.
Absolutely.
You could be at risk for certifying a payment when you are or have knowledge that a contractor has not made the payment, or his sub may not have made the payment that the sub was entitled to.
Alrighty, well, thank you very much, Anthony. Kevin also snuck in while Anthony was talking, saying that he agrees with that, and the request for the owner being informed, but indicated that also should probably make sure that the sub or the sub-sub is putting the request into writing and not just a verbal request. We do have some additional comments here. Chuck indicated he'd refer the sub-sub to the general contractor and then follow up with the contractor to confirm that they've been contacted on the issue. So I think similarly to what we've been talking about. Alan indicates here that he thinks that it's a subcontractor issue again between the subcontractor and the sub-subcontractor they're working for, and he indicated that he didn't believe the contractor in general, he assumes, has any immediate bonding responsibility unless they don't pay the subcontractor. And then lastly, some info here from Brian indicating he would review the previous pay app to determine the percent complete approved as the last application and determine if the sub is entitled for payment from previous applications. If so, he would contact the contractor to determine why the subcontractor had not been paid and alert them of the subcontractor's request. And then lastly here, Steve just put in probably to specify partial release of liens with applications. I don't know if we have any more comments related to that, or Jim and Douglas, if you have anything you'd like to add.
Well, maybe Matthew, go to the next slide while Doug follows up. Go ahead, Doug.
The partial release of liens is a good point. I think most contracts require that anyway. I know that the AIA does. That does not mean that just because you get a partial release of liens with the pay app doesn't necessarily mean that the sub or the sub-sub has been paid. I would also caution you to be aware of the statutes within the areas where you practice. I know there was a case here in North Carolina several years ago where the owner ended up having to pay, in this situation, the sub-sub twice. He had paid on the pay app that the contractor submitted, and subsequently, when the sub-sub filed suit, he ended up having to pay the sub-sub again. I don't have that case in front of me. I mentioned it to Jim and to Matthew. I am out of my office in another office where they were gracious enough to put me up in the space where I could join in on the call. But if anybody's interested, I can look that up. That's specific to, or maybe it's probably specific to the state of North Carolina, though.
All right. Well, you see that some of these questions here that we've sort of delved and dug through. The last one, I think the request of information certainly should be responded to and shared, and you shouldn't decline that request when it's come to you. And I agreed with the comment about getting it in writing rather than on the phone. But I'll say, just in my experience, that the bonding companies have almost, belligerent is too harsh a word, and I shouldn't use it, but our experience has been that frequently when you try to make some phone call to them or to make them aware of perhaps something that's occurring on a job, their response is, don't call back until you've gone through the process to file the formal claim. It used to be that they'd like to know that things weren't going well, but perhaps not anymore. I wouldn't dare suggest that you ignore this phone call as hearsay, because as Doug pointed out, there have been times where when someone did not respond to an allegation like this, that they ended up getting their firm in trouble. So it's certainly not something to be ignored. We'll go to the next proposition, Matthew.
Alrighty, just final thing here from Anthony. He indicated that the GC would typically have flow-through payment clauses in their subcontracts, which would give them an interest in the issue. Lien release are critical throughout the project. And with that, we're going to move on to the next slide then here for you, and number 3 should be on the screen momentarily here.
Jim, I'll go ahead and read this one, and then you can add your 2 cents in first.
Okay.
So this one says you are designing or have designed an addition to an existing building. And in your design, you are calling for a precast structure and have specified and detailed a 2-inch expansion joint between your new precast structure and the existing building. You get your shop drawings from the precaster through the general contractor, and they are in conformance with the design intent and show the 2-inch expansion joint. As we all know, precast gets fabricated early and is usually sitting on the precaster's yard before it's shipped to the site. So the precaster's done his job. He's got the precast fabricated, and the contractor's finished up his foundations, and now the precast is being shipped to the site and is being erected. And then it's discovered that the precast is 2 inches too long and butts right up against your existing building, and that there is no expansion joint. So you're at the OAC meeting, and it's a CM project, could be a GC. The CM or GC asks you, okay, Mr. Architect, we've got this problem out here. Tell me when you're going to give me a sketch to resolve this condition. So what would you do?
And the right answer isn't lean back in your chair and gloat that it's the contractor's problem and not yours. Right. Which might be the first thing some of us would think of, because it never seems to happen this way. I'd be interested to see the responses here, Matthew. I think, one of the things that I talk about a lot in construction administration is a team approach, and working as a team and acting as a team, and trying to resolve things as expeditiously as possible. And that certainly is a way to make projects move forward, and that's a good thing. But there's a measure of responsibility with issues that has to be applied to that, and you can't just dive headlong into problem solving when there are, especially in a situation like this where there are monetary implications.
Let's put up the next slide, and people can be reviewing that and also be inputting their comments. And I want to share a brief story with you while you're doing that. As Jim said, he and I both are strong advocates of having a team atmosphere on the job sites and working with the contractor and avoiding being adversarial wherever possible. And this is not related to the scenario that we just talked about, but this is a brief story about a situation where that has helped me out, where I was doing a project on a university campus, and as you all know, parking on university campuses is tight. And a contractor that I had worked with several times in the past was doing a job on this campus that was close by where my meeting was. So I pull up and park in his job site inside his construction fence, run into the trailer. I knew most of the superintendents for this contractor. It's a smaller contractor that worked here locally, and didn't find the superintendent. Saw one of the subcontractors, asked where the superintendent was. He says, well, he ran out to get something. He'll be right back. I says, okay, well, I parked my car out here. I'm running down to this meeting. I'll be back in about an hour. So I come out of the meeting. It's been a little over an hour. Walk up to the job site, and the fence is closed and locked, and everybody's gone for the day. So I get on my cell phone, try to call the superintendent, and again, this is not my project that he's working on. It's a different project that I was not associated with. Couldn't get him on his cell phone, so I called the owner of the company, who I knew, and told him what the situation was, and he proceeded to laugh at me. And then he says, well, hold on a second, let me try to get him on the phone. I said, I just did that. He's not picking up his cell. He says, well, hold on for a second. And he comes back on the phone and tells me, well, I got another job that's a few blocks away. I called that superintendent, who I also knew, and he's going to come over and he's going to cut the lock off for you. So the guy comes over. He's laughing at me too. Cuts the lock off over and lets me get my car out. Now, had I not had a good relationship with the contractor, he could have very well have said, show up tomorrow morning and you can get your car.
It's going to be a long walk home.
So back to the issue at hand. What do you do when you're asked about the expansion joint in the meeting and you got everybody sitting around the table? So Matthew, what have we got back?
Alrighty, so we have a couple things here from Anthony here. He said he would offer to issue a rejection of the precast materials, but stated also that this would probably move to the CM for more collaborative solution generation within the project. At the same time, we have from Kevin here indicating it's unclear where the problem may lay. Did the shop drawing actually indicate full compliance with the contract documents? If not, then the contractor should propose a correction. But from the scenario indicated, the effect on the contract times of possibly refabricating the precast is unclear. That was from Kevin. We have from Alan indicating he believes it truly is the contractor's and the precast fabricator's problem to deal with, but we owe it to the owner, their client, to work with the construction team to help resolve the problem. And we have a couple more popping in here. I'm just going to clean up my screen. Chuck Coleman indicated a sketch is not required because the layout already appears in the CDs. The question to the GC is about reaching out to the engineer of the precast to see what kind of fix might be possible. And then lastly, Billy Mathis here indicated that the CM should be informed of the informed that the precast company who submitted the approved submittal should be asked to provide a solution for review by the team. He would not take on the resolution of the problem as the situation was not a design issue.
I think I'd like to follow up on that, Doug, and you know, that I think is a critical point here, that there is a way to move forward as a team to come up with a resolution depending on the severity of the schedule and the requirements of the project. It may be prudent for you to develop in writing some historical information for the file that's distributed to the contractor and the owner, so that the responsibility and where that lies, because let's assume in the scenario that the shop drawings did match the contract documents and this was a failure somewhere between the general contractor and the precast provider, that you want to be clear of that responsibility, especially in projects that have liquidated damages and potential other fines and fees. So it would be important to document how you got here, I believe, with an owner, particularly if they are not so sophisticated an owner that they would understand this.
I think that's right on point. You certainly will want to document why you got to where you got to, and in this scenario it was described that the shop drawings were approved and did conform. They did have the expansion joint in it. As Jim said, the right answer is not to sit back and gloat and say, well, it's not my problem. Again, working as a team, working to help resolve the issue is going to benefit the project, definitely. It's going to certainly benefit your owner, and I think in the long run it's going to benefit you as well. I would not offer up actually creating a solution. I would offer up, well, I can help discuss options. I would certainly offer up, I will review whatever it is you propose to fix for the solution would be. Again, assuming schedule is an issue, I don't think just an outright rejection is necessarily the right approach. It's not gonna, certainly not gonna win you any friends with the contractor or the precaster. So working cooperatively to resolve it, helping to, whether it's coming to a meeting and sitting down and bouncing ideas, letting them bounce ideas off of you, just working as a team member to try to come to a resolution that's going to be as close to a win-win for everybody as possible.
And to add on to that, Steve Brennan indicates here that even though it's the contractor's fault, perhaps have them propose a correction, since the fabricator may have already run into this before, and there may be an easy solution that comes to the table.
There you go.
That's something that we all need to be conscious of, whether it's a situation like this or a situation where we've perhaps done something that we shouldn't have done or have missed something. Is getting the input from the guys that do this every day. They have seen those particular situations a lot more than we have, and relying on them or getting their input to help fix situations is invaluable.
Absolutely. Absolutely. Matthew, you want to go to the next scenario? So you are on the project and find out that there has been a change made in the field that violates the building code in your area, and are told that that change has been made by the owner who instructed the contractor to make that change. What do you do now?
This came up in one of our previous webinars, and it was asked again by one of the attendees from last month, so we thought we would just offer it again with this scenario. So anyone that was, and I don't remember how long ago, whether it was 2, 3, 4 months ago, anyone that was on the webinar at that time may be able to offer some feedback based on what we talked about when we had this issue up previously. Anything coming in, Matthew?
We have here from Chuck: notify the contractor and owner that the change violates the code, and then offer possible alternatives.
I like that one.
Matthew, you want to go to the what do I do now? There you go.
There you go.
Prompt some conversation here.
We have here from Anthony, while everyone else is still looking at that, indicating that your license is on the line, and notify all the parties of the issue, assuming that it was made possibly in ignorance or just of unknowing. And Alan indicates in very large, bold letters, document, document, document. Make sure you send a letter to the owner and the contractor documenting that the change is not in accordance with the code, and agree that you should offer to find alternatives.
I personally sort of like number 3, which is the tattletale motion of meeting the building inspector out there next time and carrying him over by the hand to show him what is non-compliant. That goes against everything Doug was just saying about trying to build a positive team experience, and I think that's not really the way to handle this. You want to think that maybe the owner did something out of passion and was ignorant to what the implication was, associated with the building code. So it wasn't something that they did on purpose. But I think you absolutely want to have in writing that this is work that's not compliant, that can't stay the way it is, and that you have to work together to get it resolved. And there may be times when that local authority might have some influence and persuasion on the owner if there's an issue with that owner making the change.
And in North Carolina, the rules that govern the practice of architecture require us to report it to the authority having jurisdiction. So check your licensing laws as well. What I would do is I would certainly inform the owner and the contractor in writing, and maybe verbally first, depending on if they're present at the site or not. And I would let the owner know before I went to the authority having jurisdiction that by law I'm obligated to report this, unless we come up with a resolution for it. That's assuming I wouldn't report it if we got together and the owner says, yeah, I made a mistake, or I understand, let's fix it. But if the owner was insistent in saying, no, that's what I want, we're going to do it that way, then I would tell him I'm obligated to report it to the authority having jurisdiction, and I would do so.
Alrighty.
I'd be curious as we, I'm sorry, Matthew, just real quickly, I'd be curious if anybody's ever actually run into this situation before.
We haven't indication of that yet, but Chuck brought up, from when this was brought up a few months ago on the call, that when it was discussed a few months ago, the question was whether to notify the AHG if the owner and the GC balk at pursuing an alternative course. So that means Jim's idea at number 3 kind of lays into maybe the next step after the idea we had talked about here of maybe notifying them and giving them alternatives first. And then Billy Mathis brings in here, this particular situation presents a potential for major problems. The owner and contractor should be notified of the violation, document the change instruction in the site visit, and then work with the owner to ensure he understands, and the contractor, that non-compliance is not really an option. Also inform them that there are implications that could require you as a professional to report the proper authorities and resolve the issue legally.
Well, and let me jump in there, Matthew, and say this is an opportunity. If we play this, and there are different ways to play this scenario, is something that the owner did, subversively, and they knew it was wrong and they were trying to get something accomplished. But if we take the high road and say, well, they wanted this change, they wanted that entrance moved from here to there, it exceeded a travel distance and they couldn't, but they were just doing it because they thought it would look nicer or some scenario like that. It's an opportunity for us as professionals to have, a teachable moment with our client to say, this is why you need us, and this is why we're here, and this is what the design profession keeps you from going through. And remember when we started this project together, how we set up this chain of communication, and this is why. So not to say I told you so, but to show them that there really is a relevance to how communication occurs and how changes are made, and that's all outlined in the general conditions so that this kind of thing won't happen. Any others, Matthew?
We have one from Evan. I wanted to verify if Evan, if you can speak, if you're on a phone or you have a microphone. He has actually experience with this. But while that's going on, Billy also indicates that we did have this come up once in his location as well. So Billy, if you can talk on the phone, let me know as well. He notified the owner and the contractor of the issues, and we're promptly the contractor. Oh, sorry, he notified the owner and the contractor of the issues, and were properly fired from the job. We documented the situation totally, up to and through termination by the owner, and forwarded the documentation onto the AHJ. Looks like Evan cannot, as neither can Billy, as they don't have phone connection. So technology has thwarted us from having first-hand conversation at this point. But Evan indicated here that as a floor sub, he often discovers 2-inch sand blotter layer under slab to receive flooring violates the CalGreen, but usually after slab is placed. So it sounds like he probably has to deal with this often. It'd be great if you can even just type in some of the ways you've handled it in the past, Evan. That'd be great.
It's interesting to comment that the architect was terminated after bringing it to the attention of the owner and the contractor. I personally would rather be fired than to lose my license. So I think reporting it was the right thing to do.
Doug, that might be a whole nother webinar right there. Termination.
Yeah.
Wow. Pretty drastic response. Well, Matthew, you want to go to the next?
That doesn't sound like the owner was innocently making a change.
No, it doesn't. Sure doesn't. Wow. Well, scenario number 5, sort of similar to number 4. Without your knowledge, the owner has again enlisted the contractor to do new work, additional work, and it's significant. And you didn't have anything to do with the design of it. For whatever reason, the owner doesn't want paperwork, doesn't want a new contract. They just want to do this under the existing contract that they have. And again, you haven't done any design work here. That's happened in another way. They don't hire you to do the construction contract administration for this additional work. So perhaps it's on your project and is adjacent to or is some further finish or completion of some space that you've designed, and you're not involved with the CA piece of this work either. However, the owner does want you to do the paperwork, create the change order for this work, add it to the existing contract, and also let it show up on the application for payment for which you are reviewing for the balance of the project. So what would you do in this scenario?
We had a couple of requests for topics on payment applications, and that's where this one is coming from. Jim mentioned earlier, proper processing, proper certification of payment applications is very important because it can certainly put you on the hook for having to pay for an improper certification. Be it that you have certified that the work was, in Jim's example, that the work was on site, or store materials were on site when actually they weren't, or work is developed to a point to where you're saying, yeah, they're 50% done with structural steel and they're only 10% done. You can certainly be on the hook for having to write a check for that difference in that amount that's actually in place versus what you have certified.
Matthew, why don't you go ahead and put the responses up, and maybe that'll prompt us since we're getting close on time.
Sure. We have a few coming in already. Evan, we'll get to yours in a second. He responded back with how he handled number 4. But for number 5 here, Anthony indicated just a question, is it a change to the permits? As a big question there. While Alan points out, again, that we need to, in all capital letters, document, document, document. That we are not responsible for the design and the request for additional service to do the CA work for the additional work. And then Kevin points out that the AE needs to determine if the additional work affects the project's design intent as expressed by the contract documents, or if it presents professional liability to the AE. And then lastly here we have Chuck pointed out here that he would politely decline. They have the resources at their disposal to develop the paperwork, document the situation for future reference in case the idea turns into a claim.
Before we jump back to number 4, this has actually happened to me on a couple of different occasions. One recently was a project where the owner, separate and apart from the project that we were working on, wanted the same contractor that was doing our project to do some work on a parking lot that wasn't in the immediate vicinity. Did not want a separate contract with the contractor. There was no need really for documents. It was a simple resurfacing or something like that. And just wanted to do a change order to this contract so the contractor could go over there, resurface the parking lot, get paid for it, and move on. Having a long-standing relationship with the client and not wanting to damage that relationship, what we did was we went ahead and did the change order. We did not provide CA services. And when the payment application came through, and this was discussed with the owner so that it wasn't a surprise to him, he understood our point of view and our situation and agreed to this. But on the payment application itself, we noted that our certification was only for our part of the project and did not include change order, whatever the change order number was. And we were taking no responsibility and not certifying or authorizing payment or recommending payment for anything associated with that change order.
And I think that again is we have circling around this team approach to what you're going to do on the project, in notifying people, communicating, documenting, and some of these drastic ideas of discontinuing service or just going ahead and doing it and letting it go are not good selections. Matthew, are there any others there?
There are not at this point.
Okay. You want to go back to number 4,
Sure.
or you want to go?
We're just gonna, yeah. We'll move forward to the next one here. Probably is our last one for the day. And while that's going up on the screen, Evan gave us some feedback on his experience with question number 4, with the work being done outside the purview of code. Indicated that they try to RFI it right after the bid, but rarely are they under contract before the slab is placed. Usually that results in their material being cut out and a new sub being brought in who will violate the code. So I guess if we do a termination topic in the future, Evan probably will have lots for us to learn from. So with that, I guess number 6 is on the screen. If Jim or Douglas, you want to read that, and we can start getting some feedback. I think this will probably have to be the last one for the day, though.
Real quick, you get a request from the contractor for CAD files so they can prepare shop drawings. Your contract with the owner provides that you give up ownership of the documents upon completion of the documents, so you have no rights, including copyrights to the documents. Your contract is silent about you transferring any CAD files to the contractor. The only deliverables you have in your contract are the CDs that are used for construction and then record drawings CAD file wise at the end of the project. So what do you do? How do you respond to the contractor's requests for your CAD files? And let's just go ahead and put the answers up since we're running short on, go to the next slide, since we're running short on time, and people can be reviewing those as they are inputting their responses. So as you can see here, what do I do now? 1, provide them as requested. 2, develop a release to be executed that would allow you to share them and get it executed. 3, decline and direct the GC to the owner. 4, work out directly with the GC in agreement to share the CAD files as they've been requested. I am sure that we have run into this situation before.
Alrighty, we have 2 popped up here quick. From Kevin again. Here we have, while the AE has no obligation to furnish electric files, normally I would use my firm's standard agreement for release of electronic files. They are still the AE files until the end of the project. In here from Billy, here we have, there are no input on release of the CAD files. We have a release form which not only specifies the rights for use under the limited circumstances and applies a fee per sheet for those files. In his case, it's $50 per page plus the cost of the media. Without the release form, the files will not be released. And then Anthony adds in here, the owner needs to be involved as they are the ultimate owner of the IP.
I would add to those comments, one, in the fact pattern that said that the ownership of the information transferred to the owner upon completion of the documents, not completion of the project. And I've seen that in contracts before. I would certainly, if I was going to, well, again, and I've talked about being a team player, I would try to find a way to be able to transfer the CAD files. I do think that you should definitely have a release form that could be another topic, and I'm not going to go into all of the stuff that should be in a release form, but that basically waives liability for you allowing them to use the CAD files. I also think that you should be compensated for it, and depending on your relationship with the owner and the contractor and the project, you may or may not be successful in convincing them that you should get compensated for doing it. Typically it is a nominal fee, $50, $100, which usually is just enough to cover the time it takes to prepare the information to give it to the contractor. It's not a money-making proposition, which owners and contractors seem to have trouble comprehending. You need to, especially if your contract says that the ownership has transferred to the owner, you need to make sure you get the owner's permission to do so in writing. If you don't, you could be violating copyright and transferring that information to the contractor without getting the owner's written permission first. Anything else, Jim?
No, I think you covered it.
Yep, just wanted to put, Stephen points out how this might be another future topic for us. As well, Stephen, I'll propose this as a future topic maybe as well for the BIM practice group. He indicates work out an agreement with the GC for using the firm's use of electronic files. For another session, what happens when BIM models are requested? So that's kind of a fun one to think about, considering we do have to start thinking now about not just CAD files but BIM models, which the intent behind it is to have other people using them to be able to input their information. And then also Chuck Coleman indicates the same thing I think we kind of already talked about. Just request permission from the client to release the drawing files to the contractor, with a disclaimer regarding the contractor's use of the drawing files is for the purposes of construction on that specific project.
And again, we welcome any suggestions you have for future topics that you would like to see discussed. And we thank you all for participating. Thank you, Jim and Matthew.
Thanks, everyone, and have a great day.